On today's show, employment law in California takes center stage. Hi, I'm George Whipple. California has passed a new law that states a person shall not, as a condition of employment, continued employment, or the receipt of any employment-related benefit, require any applicant for employment or any employee to waive any right, forum, or procedure for a violation of any provision of the California Fair Employment and Housing Act. But many employers and law firms are taking the position that the legislation is preempted by the Federal Arbitration Act. Kevin Sullivan tells us more.
We can expect to receive challenges in the coming months from employers doing business in California as well as business groups arguing that this new California law is preempted by the Federal Arbitration Act.
Home to 1/8 of the United States population, California is a bellwether for states across the country. And that's why we're keeping our focus there this month. David Prager has an update on other changes coming to the state in 2020.
This year, Governor Gavin Newsom signed almost every employment-related bill presented to him by the California legislature. Assembly Bill 9 extends the time to file a complaint alleging employment discrimination and related claims with the Department of Fair Employment and Housing, the administrative agency generally charged with enforcing California's employment and civil rights laws, from 1 year to 3 years. Assembly Bill 749 prohibits settlement and non-negotiated severance agreements from containing provisions restricting a person from obtaining future employment with the company. AB 5 writes into law the ABC test set forth in the California Supreme Court's 2018 Dynamex decision. To establish that someone is a contractor under the now codified test, a company must show that the worker is free from the control and direction of the company, performs work outside the company's usual course of business, and the worker is regularly engaged in the work that they were hired to do, independent from the work being performed for the company. While a nationwide ABC test or federal ban on arbitration are unlikely under the current political environment, they could signal larger changes in the not-so-distant future.
Continuing our focus on California, employee data gets a brief reprieve from the California Consumer Privacy Act, thanks to one of several amendments made ahead of the Act's effective date on January 1st, 2020. The CCPA gives consumers rights over their personal information, including rights relating to the access and deletion of that information. Because the law defines the term consumer broadly, those rights would extend to information that an employer maintains regarding its employees and job applicants. The amendment creates an exception to many requirements of the CCPA for the personal information of employees and job applicants, but only until January 1st, 2021. And that brings us to our tip of the week. Allison Olson, Vice President of Human Resources at Abode Healthcare, is here with some tips for California employers and for those in an increasing number of states across the country with legalized marijuana on best practices for determining your approach to drug screening.
Enforcing drug-free workplace policies and conducting drug tests is becoming particularly risky. First, you're going to want to make certain you do a detailed review of the state laws that cover drug testing as well as non-discrimination. Effective communication and a clear understanding of your policies is imperative. Your employees must understand that if they were to come into the workplace or work while under the influence of marijuana, it is strictly prohibited. Even if in that state they're working in, marijuana is legal to consume recreationally or medically, it's still prohibited in your workplace. So the law and court decisions are going to continue to evolve over the coming years. It is crucial that you as the employer, that you continue to check your policies, your procedures around drug testing and ensure that they still meet your business needs and are effective.
Thanks, Allison. And thank you all very much for watching. We'll see you next time.